There have been some activity in other jurisdictions, Florida, Washington, and also California. And thanks to Alicia for providing us an update on what happened recently in California. Those materials were attached to your minutes, to the PDF invite for this meeting. But I think, Brian, it would be helpful if you maybe gave an overview for those that have not had a chance to study those, what is happening in those other jurisdictions in connection with regulatory change.
Absolutely, it's my pleasure, and good afternoon, everyone. Florida and Washington really provide the, I guess, some of the more significant updates over the past quarter. Florida in particular. Florida published its report. It's a very long report. It's a very detailed report. It reads almost like a law review article. But ultimately, they kind of went through their thought process, their study, including the history that they've seen, particularly with regards to Arizona and Utah, and came out with a number of different recommendations for where the Florida bar, where the subcommittee feels like the Florida bar should go. Their biggest thing, there's a number of different ideas in here, but what I would really distill it down to is they are interested in pursuing a regulatory sandbox of sorts. Now, within this regulatory sandbox, they want to try a couple of the ideas that we've discussed. They're kind of lumping it all into a pilot program where they want to try a bunch of different regulatory change ideas, including alternative business structures and limited paraprofessional licenses. So they've got a couple of different proposals. There's some advertising rules and other rules of professional conduct that they are studying, and they are recommending be essentially reviewed, if not eliminated in some cases, like fee sharing, the prohibition on fee sharing with non-lawyers. But they're really all proposing it to occur initially as a pilot project in Florida. Where that really goes, this is a special committee of the Florida bar that's submitting this to the Florida bar and ultimately to their Supreme Court. So it's I think it's going to be something to monitor, and certainly we will do that to see exactly what action the court takes. In kind of a similar way, Washington State, they were some of the I guess the trailblazers in terms of regulatory change with initially their limited license legal technician program, being really the first one in the United States. Although they sunset that program, there's still, it seems, to be an appetite for regulatory change in that jurisdiction. And you'll see in your materials, there's I included really for both Florida and Washington different articles that have recently been published about what those jurisdictions are looking at, what they are proposing. Washington, they are looking again at a regulatory sandbox, another jurisdiction looking at the regulatory sandbox. They have a blueprint for their legal regulatory sandbox that essentially would be kind of a 3-year project. And again, without getting into a great deal of the detail, it's very similar, I think, to what we see over in Utah. Arizona, I have to say, is probably proving itself to be the most bold of our United States jurisdictions because they just did the change. They just changed the rules and just said, let's give it a try instead of doing a sandbox or pilot program, however it's set up. So, but Washington has this blueprint. Again, this is a proposal. Whether or not that gets implemented is something that we will continue to study. But it's I think it's fair to say that there are a number of other jurisdictions. Of course, we looked at that at the very outset. There's a number of jurisdictions that are looking at these different things. Of course, North Carolina, you can see in one of those published articles, North Carolina was referenced as another jurisdiction, along with New York and California and so forth, that's looking at a variety of different changes. They are drawing their conclusions. These particular jurisdictions are drawing their conclusions in favor of a regulatory sandbox. But of course, that's a pretty big task, and how that goes through, we will continue to monitor and report back.
Thanks, Brian. I appreciate it. And in case you're wondering why regulatory sandbox isn't on today's agenda, I've asked Jeff to kind of think about the regulatory sandbox, and at our next meeting, which is probably going to be late August, I don't think we've got a date finalized yet. I'm going to ask Jeff to kind of give a report on some of their thoughts around regulatory sandbox. We'll have that discussion then, and then kind of get input from the committee as to whether we want to make any recommendation on a regulatory sandbox. So, but you do see 2 other jurisdictions moving forward in that direction. So it's something there's clearly interest in. And we have not decided what our recommendation will be, but I wanted to give Jeff some more time to put together that. So we'll get a report from them, but I want everyone to be thinking about, pros and cons, what your thoughts are on, Brian, thanks, Brian, just put in the chat. Yes, August 25th is our next meeting. Thanks for that reminder. So a month from now, we'll dive into regulatory sandbox. I think it's great, Brian, that you circulated these materials, because I think it is a good look at what other jurisdictions are doing, and something for us to think about as we consider whether a regulatory sandbox is something we want to do. One other thing that struck me is the role of the courts in the regulatory sandbox, is something that is interesting and somewhat different than where we are in North Carolina. Some of these jurisdictions, it's been very much a court program where the court is really saying, we're going to do this sandbox and create these exemptions to our rules. Whereas this is something, our efforts really being led by the bar, and then we're talking to the courts about it. So there is an interesting dynamic in terms of how that would actually happen and get implemented if we decide to make that recommendation. So I think we should think about what should happen and then figure out how to make it happen. But there are definitely some hurdles, and I think we need to go in eyes open that's the environment and the involvement of the courts is a little different in North Carolina than I've seen in some of these other states. Brian, the other jurisdiction, and I know we got the information from Alicia, I think after you'd already circulated these items, is California. California has moved forward with a paraprofessional program and made some decisions, although there's still others along the way. But it is a model somewhat like what we're discussing in terms of identifying specific practice areas where paralegals may be allowed to focus, and then trying to come up with those rules and licensure requirements. One thing that I found particularly interesting was a proposed timetable that kind of had the start of a working group in 2020 all the way through final implementation and approval of the program in March of 2023. As someone that likes to get stuff done, it's a little discouraging to see that it's going to take, it took 3 years, or they're projecting 3 years, basically from working group convening to the end. And that's for not a statewide program, but for, they decided to only do part of the state. Obviously, California is huge. They've identified particular counties where they're going to implement it in California. But I did think it was useful, and it'll be useful to the Ad Hoc Committee I'm going to talk about in a minute, I think, to see the different pieces and how they broke down the task in terms of what decisions needed to be made and when they got input and the various steps. So that was interesting to me. And there's some overlap in the practice areas, but it's not identical. There are other areas that I think we were less sure would be a good fit that they at least initially seemed to be including. So a lot of good information there. And I think maybe, Brian, with the next minutes, for people that want it, we can include it. But that's interesting in California. And Alicia, if there's more you want to add on California, you're welcome to do anything else you want to add. I appreciate you forwarding those materials. Anything you wanted to highlight for this group? Oh, thanks, Brian, for that. Yeah, putting up the screen. Go ahead.
I didn't really have anything additional to add.
Okay. Thanks, Brian. You're way ahead of me. I didn't know we had a slide. Could he so easily put up the slide on the one-page summary? But this is, again, I think very interesting. And actually, it's only one page. It's worth looking at it. So, and I'll just talk and give you my impressions, and then we can have a discussion, and then it'll flow right into the recap of what we reported to the State Bar a couple weeks ago. One area that I think I assumed would not be included was criminal. And they are not including what I would consider traditional criminal work, i.e. representation of criminal defendants, because that work is provided by public defenders and is state sponsored. They did identify a need around what they're calling collateral criminal, which is expungements, reclassifications, and certain infractions where you might not have a right to counsel. And I thought that's interesting. I know, having done a little volunteer work in the expungement area, there is a need. I know the legal aid folks are trying to do some of that. I don't recall where the expungement, if it was discussed in the legal needs assessment for North Carolina. Does anybody is that covered there? I don't remember seeing it, but I see you shaking your head, Brian. I don't remember them talking about it. So we didn't list it as when we were prioritizing the 14 areas. I don't think the collateral criminal was included. They like we found needs in the area of family law and custody. I think it's interesting in that their list is potentially a little larger than the list we were talking about in terms of including property division and child and spousal support. At least in some of our discussions, there were questions about whether things like property division and spousal support would be included in scope. And obviously, we don't have any decision yet on what the scope will be, but I did think that was interesting. And things like adoption and guardianship, we didn't talk about explicitly. We talked explicitly about custody, domestic violence, and I think those are the two kind of top priority items that we identified. And again, I won't read it all. We had some discussion around consumer debt. They tried to put a little more definition about that in terms of garnishment. Landlord tenant was on both lists. I don't think they list foreclosure. That was an area we had identified as potential need. And then they've got some specific stuff with the employment and income maintenance with wage and hour, which again might be worth us thinking about, was not specifically identified in our needs assessment. Let's look at the second page, Brian, in terms of requirements. I think just people will be interested to see what they decided on.
I was going to add, Mark, just the most amazing thing I thought about this proposal was the ambitious thought that they could submit legislation to the legislature in California in March, and it's going to be ruled on by September. That there'd be a 6-month window to get something passed. It's
ambitious.
Yeah, that's ambitious. That's it.
not often the experience with the legislature. They also spent time doing, and again, this is an area that the Ad Hoc Committee, I'll talk about in a minute, will be doing, not something for our committee, but since we invested so much time thinking about limited licensure, I thought you might want to see where they ended up in terms of some of the eligibility. They are basically, they have a legal document assistant program. So those folks would be qualified in addition to paralegals or JDs. And that's an area where, until I read it, I was thinking JDs, aren't they lawyers? But obviously there are a number of unlicensed individuals with JDs that could potentially get a paraprofessional license, even if they, for whatever reason, could not get a full lawyer license. Then they had some units and hours in different practice areas, which I thought was interesting, including more what I'll call general practice requirements around advocacy and other stuff, and then some specific stuff on family. My initial thinking was that the shift might be different in our program where we'd have more practice area specific stuff and less general. But again, that's a decision for a future committee to make. You see their training requirements, testing requirements there. They decided on $100,000 surety bond. Some jurisdictions that have adopted this have required some kind of malpractice insurance. As you know, North Carolina does not have any surety bond or malpractice insurance for lawyers. So I think the issue would be whether we want one for paraprofessionals. Going to be something for a future committee to think about. And then some scope of practice, limits, but they're saying in court, the only thing that they know is excluded would be jury trials. So just an overview of what they've done. And again, I present it. Yeah, Jeff, did you have a question? Yeah, Jeff Summerlin Long, go ahead.
Yeah, I'm sorry to interrupt. I was just thinking about the JD thing there, where you could have a JD and you could have failed the bar exam, or that kind of thing. But I don't know the numbers, but I imagine there are a decent number of people like me who have a license but are inactive, and who would be interested in doing some of this stuff. And so I think it would be, good to make sure that we cover that, especially as a former legal aid attorney. Obviously, I'm kind of into this stuff. And I know of at least 5 other people like me, so there must be a decent number.
Thanks, Jeff. I think it's a great point. And again, in my mind, I've got as someone who's serving as a paralegal now that wants to do this additional work, and that may be our biggest group, but you're right. I think there are a number of inactive people with an inactive license, or just didn't get licensed, people that may not have passed the bar exam or don't want to take the bar exam, or a variety of reasons where if something were more accessible from a training program and they could do it and get licensed and do some of this important work, might jump at it. So I do think that's a great point.
Well, and you can also think about law professors, a lot of whom aren't licensed.
Yep.
So
yeah, no, that is a good resource. Mac, go ahead, Mac. I see you.
If we were going to do that for people with the JD, I might want a restriction that says not if you've been disbarred.
That would seem logical to me. Yes, right. There shouldn't be a backdoor way into practicing. If the state bar said you can't do it, that would certainly make sense. So, as a reminder, we spent a lot of time talking about limited license paraprofessionals in our last meeting. We voted on a number of the priority areas. I gave a report to the Issues Committee and then again to the Executive Committee 2 weeks ago with a recommendation that the council, the officers of the council, go ahead and appoint a new ad hoc committee of the state bar itself, with the task of doing further study and then actually basically drafting a proposal for paraprofessional licensure. And to kind of I view it as a handoff, right? We were supposed to study and say what is worth further development. This committee felt like paraprofessional licensure is an area worth further study. We need an ad hoc committee to really look at what the program looks like, look at all the things on the California one-pager that you just saw, that we had some discussions about but made no decisions on, to really put together a program. What would it look like? What would the training be? What's the scope of practice? What supervision, if any, is needed? Who's eligible to do it? A lot of questions need to be answered, and that ad hoc committee would be charged with doing that. And that recommendation was adopted by the Executive Committee. So the officers will be appointing an ad hoc committee. I don't know that we have a definite timetable, but I'm thinking, probably within a month, one would get appointed. There may be members of this committee that get asked to serve on that ad hoc committee. I think there's going to be an effort to make sure we've got representatives from the judiciary, from paralegals, from other stakeholders in this process. Again, the officers will decide who they want to name and make those appointments. But I'm excited about it. I think there's obviously a lot of work to be done, but that committee will be in a position to develop a detailed proposal that then could be presented for the state bar for adoption. I've also suggested that ad hoc committee will need to create some subcommittees to look at a lot of the challenges we looked at, like what kind of legislative changes needed in terms of a statute, what do we need to change the definition of the practice of law, what kind of licensing is going to be done, and what entity would license them. Is it the Board of Law Examiners or some new entity? So there are a lot of logistics questions really beyond the scope of what we did that this new committee will have to tackle. But I'm excited. I think it was well received. I got a few questions at the Issues Committee about, what's the scope going to be? How's it going to impact other people's practice? I think we can certainly anticipate some of those questions from other members of the council and other lawyers as they understand what we're doing. As we had talked about, I really focused on the legal needs assessment, and we heard a presentation on the legal needs assessment, and that has been circulated to all the council. So I think there's a recognition that there's a lot of unmet needs, and the idea of limited licensure may give people some representation where they have none. And I think that that notion, I think, has widespread enthusiasm. Obviously, there's a lot of logistics and details and a ways to go before there's something that the state bar can vote up or down. But I think it's a positive step in development. I felt like it was well received. We had some good questions. I had great discussions with a number of different people during the course of the meeting a couple weeks ago. So that's where we are on on the paralegal licensure. Very briefly, they also adopted our suggestion of making a recommendation supportive of the court navigator program. So I think at some point the officers will be conveying that. As you may recall, there's not as much for the state bar to do because those are not lawyers or any kind of licensed individuals. Those are really staff that would serve in the courthouse and help people navigate the process. Given how successful it was in New York, I'd love to see it in North Carolina. There's obviously hurdles, including budgetary hurdles of whether, how's that going to get paid for? And is the AOC, the Administrative Office of Courts, going to pay for that? Or individual, or the court systems in the various counties going to pay for it? So I think we'll make that recommendation. It'll really be up to someone in the court system, I think, to take that recommendation and move forward with it. It's not something we can accomplish through any change in the rules of professional conduct, but I do think court navigators had promise. So that was also adopted in terms of something that will be moved forward on. So that's a kind of a report on where we are on those two things. Before I move into the areas we haven't dug into yet, let me just see if there's questions, comments, or thoughts on the limited licensure issue or anything else on that front before we move forward. All right, hearing none. There were some other ideas that we spent some time on, and for those of you that like me have a hard time remembering, some of these were things we took up a year ago when we listed what some other practice areas were doing. They're listed in the agenda, and there are four that I wanted to think about. One is liberalization of unauthorized practice, another's alternative business structures, another's fee sharing with non-lawyers, and then alternative admission to the bar. The way I thought we'd talk about these is I'm going to ask Brian to maybe give a short recap of what each of these, what we learned, what other people are doing, and kind of what the idea is there. Then have a discussion in our subcommittee about it, and then a vote. And again, the answer will not be necessarily a, yo, yes, we got to do this now, or no. The answer is this something we want to report back to the issues committee at our next meeting, I guess in October, and say we recommend that this be studied further, or do we not recommend it be studied further? In other words, we're kind of that funnel to say, is this a good idea worth further study and development, kind of yes or no? And we focused on that limited licensure, and we said yes, do further study. These we've spent less time talking about, but I think it's worth reviewing, and I welcome everyone's thoughts on those. So with that intro, Brian, do you want to let's lead off with liberalization of unauthorized practice and remind us what this idea is, why it has some advocates, and give us an overview, and then we'll open up the floor.
Sure, and I think there's been a lot of talk about the need to open up the unauthorized practice of law rules, kind of from a variety of perspectives. I think there's been different conferences, whether you're talking about some of those professional responsibility conferences, or even just kind of how the liberalization of UPL rules touches on, you say, the introduction of a limited license for paraprofessionals, or the general notion of a company that can come in like an alternative business structure, or maybe just an online provider that can streamline services. And of course, we do have, particularly to that last point, we do have an amendment that came about a couple of years ago, following some litigation, that allows some online providers to give legal services to the citizens of North Carolina. But generally speaking, what I would point out to you all in the materials, in particular for this agenda, I included a chart that the ABA put together on the different definition of the unauthorized practice of law. Generally speaking, kind of without going through each jurisdiction, kind of take that step back and look at our definition, North Carolina's definition of the practice of law. You see it there. It's in Chapter 84. I included all of Chapter 84 in your materials, and particularly 84-2.1 defines the practice of law. Now, with regards to, I know we've already recommended the limited licensure, and I think we briefly touched on this at the last meeting, but we don't necessarily need to amend the definition of the practice of law necessarily with the limited licensure. We just would need to amend the statute, I believe it's 84-4, that says that essentially those that hold this limited license can practice law, and kind of, I think we would need to adjust. We need to look at the statute very carefully to make sure that it's capturing and empowering those that we intend to empower, but not, either making it too narrow or too broad. But nevertheless, the general idea with the liberalization of the unauthorized practice of law is just this, I guess, this question of, should other people be able to provide legal services? Should it really be as restrictive as it is? Because our definition in North Carolina is essentially any legal service is considered the practice of law. If you provide legal advice, certainly if you represent somebody, you can see there in 84-2.1 the encompassing of different draftings of wills and appearances before judicial or quasi-judicial bodies, assisting by advice, counsel, or otherwise in any legal work. And that's incredibly broad. But you'll see that definition or that description in a lot of the other jurisdictions in that table. Just by chance, you can if you open up that chart that I included, and you can use the bookmarks in the PDF to navigate to it. But the very first state that's listed there, Alabama, is actually different. They define the practice of law as engaging in a representative capacity, or for offering legal advice for consideration, reward, or pecuniary benefit. There's some specific circumstances that would result in you practicing law, but just the casual person that says, "Hey, I know X, Y, and Z about the legal process because of my own experience, and here's what I think of your situation." If you're not getting consideration for that, or you're not getting some sort of reward for that, then from what I'm reading of Alabama's statute, it sounds like that's not the practice of law. So I think there are opportunities, maybe opportunities or just options, I should say, different ways that people do approach the practice of law. But I have to say, in reviewing those different jurisdictions, it seems like North Carolina is kind of, is very much in the majority group. Most folks broadly define the practice of law as North Carolina does. And I think that's kind of the interesting thing about this conversation, despite all the talk, and I'm kind of look at Jeff Kelly here, because I know, Jeff, you've been around those conversations of, how are the UPL laws really kind of restricting practice. There's a lot of talk, but there hasn't been a lot of, action in the different jurisdictions with really amending and broadening, or perhaps lessening the restrictions that are associated with the unauthorized practice of law. So we don't have any jurisdiction to really look at, unfortunately, with regards to this change. None of the, I think there's been some discussion about this in other jurisdictions, and some have just decided not to do this. I have to also remember here that when we talked with Ontario, I think there was a description there of how they had what they called agents that were non-lawyers that could represent folks on speeding tickets. That just wasn't considered the practice of law. So, again, there are different approaches to this, but for whatever it's worth, North Carolina's approach is pretty common. And I guess maybe that's the question to this subcommittee. Is it worth looking at our definition? Is this something that, there should be an ad hoc committee that looks at redefining the practice of law? Is that necessary, or can we maneuver within the current statutory framework to actually provide access to justice in other ways?
Thanks, Brian. Let me open it up and just see who wants to add comments or advocate for assessment or oppose it, or just who wants to.
See, Jeff Kelly has his hand raised.
Go ahead, Jeff.
Yeah, I mean, I'll kind of pick up where you tossed it to me, Brian, on the national conversations on this particular point. I think why you're not seeing sort of a kind of blanket approval of UPL, reducing or softening the UPL restrictions, is because it's taking effect in specific proposals. So it's not that anyone has given up on the idea that sort of as it exists pre, conference or committee or whatever study has happened, that the scope of what you can do without a JD and a license is broader than before they started that. But what they're not doing is just opening it up without some type of construct or path to that. So, I mean, in that sense, I don't know that this is a specific agenda item anymore, so much as it'll get subsumed into the kind of spirit of a study committee that starts the conversation. And as specific topics emerge, that's the form in which we liberalize UPL.
And it's a great way to summarize it. Thank you, Jeff. You said it much more eloquently than I.
Alice?
Yeah, I think the model here is the statute that permits law student practice. You know, they didn't change the definition of what is the practice of law. They just added a statute that says sort of regardless of the other requirements, law students are allowed to engage in limited practice under these specific circumstances. And in my mind, that's what I thought we were kind of about with the paraprofessional license, is it would just be a new statute or series of statutes in Chapter 84 that wouldn't change the definition of the practice of law, but would say, despite that, we do permit these people to engage in this kind of practice. Frankly, I think North Carolina has been rather fortunate in that we've had a really pretty good statutory definition of what is the practice of law. I've seen a lot of other states that have struggled to come up with the definition. It was all, you know, the definitions were all in case law, and just had a lot of problems with that. I think at one point the ABA actually had a committee or commission or something that was trying to come up with a definition, and they ended up throwing their hands up in frustration. So my strong recommendation would be that we not try to tinker with that, because we also don't know what genies will be released from the bottle once you would take a bill like that over to the General Assembly. Whereas I think if what the state bar ultimately does is come forward with a proposal for a statute or series of statutes that create this limited licensure, I think that frankly might be embraced. And Brian, who knows, maybe in 6 months, the General Assembly would, you know, adopt it. Could happen.
Thanks, Alice. You know, and I agree. And obviously, we've got quite a bit of case law and practical. You know, we've litigated the practice of law. There's a lot of guidance in North Carolina, so we have a, you know, there is a lot to kind of inform in the current definition. Let me see. Do we have anybody advocating to say this is something that we need to look at, or a committee should do it? Anybody feel like this is a priority where we want to make some recommendation to say we've got to revise it? Jeff Summerlin Law.
I mean, I like what Alice said about sort of maybe tacking on to the law student provisions. You know, from a policy point of view, if it's, you know, politically feasible, it's always best to change as much as you can initially, because it would become harder for, say, later legislatures or something who are opposed to it to get rid of it, at least in its entirety. You know, it's this whole concept of retrenchment. You know, if you can get the structure in place, interests build around that, and politically it becomes harder for somebody to mess with it. And, you know, so my immediate thought was an entirely new section within the statute. And I think it would be good for us who've been looking at these things in such great detail to maybe draft one. You know, at least provide, you know, some language that maybe we crib from here and there, and that kind of thing. I worry that just slightly amending things is going to leave open the potential for future politics to take it away. So, I mean, that's basically the history of legal services, right? So that's just something to think about.
Let me ask you, Jeff, when you talk about a new section, I think we've there's, in my mind at least, there's this issue of what is the practice of law, and then a separate issue of who should be able to practice law. And I think that second piece, we've already discussed limited licensure paralegal. I think one thing that we came up at the issues committee is, are there other ways to expand, you know, law school practice, or other, you know, some of the other exceptions. So I definitely think we're talking that second piece. In others, are there ways to broaden who can practice law? I guess this issue to me is, do we also want to look at, and are you advocating, or are there others that would advocate changing the definition of the practice of law as well? I'm not clear on what you're advocating there.
I would advocate changing both.
Okay. All right. And
Um,
what about the practice of law? How would you envision rewriting the practice of law? Do you have some particular thoughts on what you'd like to see and what would be accomplished if we did it?
I mean, again, we would have to directly link it to people who are qualified under the other statute, right? It can't be just like anyone giving legal advice, but somebody who is a licensed, whatever. But I know in the immigration realm, there are a lot of organizations in North Carolina that do provide limited services, including some advice. And it's probably technically a violation of the current UPL statute. But for a large segment of the immigrant population in North Carolina, that is the only thing available to them. Right. And so, that's why I envision changing both.
Okay. Gotcha. Thanks, Jeff. Any other thoughts, comments? Anybody want to talk about this? Alice, I see you again.
So I think we need to be careful when we're talking about immigration law because that's federal law. And actually the federal law permits some non-lawyer practice in the immigration realm. That's one of the kind of limitations that I think we've got in looking at this paraprofessional license in North Carolina, because the civil legal needs assessment identified immigration law as being an area of great need, but we have limited authority to do much about that here in North Carolina. The feds establish what practice is permitted in the federal courts. So, I just think that's not something we're going to be able to address.
That's entirely true. What ends up happening, just like in any law office, somebody comes in with one problem and you find out they have five. And the same thing happens when immigrants come in looking for immigration advice, and it turns out they've got landlord issues, they've got, wage issues, and that kind of thing. And I'm always concerned that these organizations are going to start doing that. And that's where the violation really comes in, right? You can get a non-lawyer certification from Homeland Security to provide limited representation in immigration, like filling out forms and that kind of stuff. But I just know when I was practicing, I might have somebody applying for asylum, but then they had other issues. Because I was at the Justice Center, I could help them to a certain extent with that. But Catholic Charities and a lot of these other organizations that do this, they can't.
Thanks. Any other thoughts or comments?
This is Alicia. I had a question actually. When you're looking at 84.4, like I know someone mentioned just making some small changes to that, but how does that affect 84.24 with the Board of Law Examiners? That was the one question that I had. And then the other question was, when they made the change to 84 in 1995 and they created the 84A for the foreign legal consultants, that didn't seem to go through the Board of Law Examiners. It says that the Supreme Court can issue a license to practice in the form of a certificate of registration. So I was wondering if anyone knew the backstory on that.
Looks like Al. We have the virtue of having Alice, who's been here forever. So
And the
Alice,
backstory. Just call me the backstory girl. Yeah, so the foreign legal consultants is actually the product of, I think, NAFTA. It was the big cross-border trade agreement back in the 1990s with Canada and Mexico. And the whole idea was that we wanted to allow for cross-border trade in services, including legal services. And they wanted to facilitate that quickly because they wanted to get NAFTA approved. So the way they set that up was that it would be overseen by the Supreme Court, and it's pretty much uniform statute. So, what North Carolina has is pretty much similar to what all the other states have. And most of the other states, their whole legal profession is supervised by their courts. And so we kind of got stuck in that pool because of the way the other states do it. Also, the foreign legal consultants, this is enabling people who are licensed in another country, for example, Mexico, to practice Mexican law in the United States. In other words, to provide legal services in Mexican law to American citizens or Mexican citizens or whatever, but just while they're in the United States. So, there's some argument as to whether you really even need to do that. Is the physical location of the lawyer really, should that dictate what kind of law they practice, or should their licensure dictate that? But nevertheless, that's what foreign legal consultants is. We right now in North Carolina, after 30 years of this, close to 30 years, we have like 4 foreign legal consultants. So it's really, I don't think it's an alternative to what we're proposing. And I think where we're talking about having people who are going to be providing some legal services to the public, to North Carolina citizens, that there ought to be a structure that is similar to the structure that leads to licensure for lawyers. It doesn't have to replicate it perfectly, exactly the same thing or anything of that nature, but I think that would be sort of an expectation of both lawyers and the public, that there's going to be some process for identifying people who have the knowledge and ability to provide those limited services. Did that answer the question? Is it enough backstory?
That's great. Any other comments or thoughts before we do a poll? Brian, I think you've got a poll set up so we can poll the committee. And again, what we're voting on is whether we want to make a recommendation to issues that this idea of revising the definition of practice of law or the definition of unauthorized practice, UPL statute, whether we want to recommend that be presented for further change or proposal. Okay.
All right. I think it looks like voting is slowed down.
Okay. And I don't know, I don't see a voting button for me, which is probably fine. But as chair, unless I missed it, I don't, that just.
Yeah. I think
it's totally fine.
Yeah.
Yes,
I think
like 10 people have voted and the results are 6-4 in favor. There's the results. So it is divided, but a recommendation of yes. So we can report that we think that a majority thinks it's worth further study by the Issues Committee.
Can I just?
Steve, I see you want to say something. Go ahead.
I voted no, but I'm in favor of Jeff's take on it, which is it's subsumed by other conversations we're having. It's not that it's a non-issue, but I think we can address it in the context of paraprofessionals or multi-jurisdictional practice. In the AP committee, just we used to have, the crossover situations, and it's not that I don't think it's an issue or something we need to present, but I just want to clarify my vote, which was a maybe.
Okay. No, that's helpful. And again, my thought is we'll just tell the Issues Committee, we talked about it. Some people think it's worth further study, others don't. They'll obviously decide, do they want to then have a new ad hoc committee? Do they want an ad hoc committee to study several things? So we may end up with 4 or 5 recommendations that we think are worth studying. And then the Issues Committee or the bar will have to decide, do they want multiple ad hoc committees? Which are the priorities? And obviously there's some extent, there's only so many things we'll probably logistically be able to explore at once. So there may also be a prioritization issue, but right now I think I didn't want to do these polls are helpful to me to just get a sense of where we are on these different issues. So that's helpful. And I think with that, Brian, I'll ask you to move on to our next area, which is alternative business structures. Again, there's a tab on this in your materials. If you want to read some of that, I think it starts at page 223. But Brian, you want to give us an overview of the what we're calling the ABS, but not braking, not automatic braking, but actually alternative business structures.
Well, I see, Lakeisha, I see you have your hand up. Before we move on.
Thanks, Brian. I missed that. Go ahead, Lakeisha.
I just wanted to say quickly, I also voted no, but I was thinking along the lines, I believe, of what Steve said and what Jeff said. So I just wanted to be clear. I think it will be subsumed in other things, and I am definitely interested in that. Excellent.
Thanks.
Great. All right. So alternative business structures. I included this. This was at Mac's suggestion, and I thought it was a great suggestion just to kind of get us all on the same page. There's one of the tabs in your agenda where there's a description of these regulatory change topics, where I tried to just kind of very quickly summarize what we're talking about. Obviously, all these ideas are much larger, much more complex than just a couple of lines. But you'll see their alternative business structures really just talks about business models, that these are different models through which legal services are provided. Really just kind of differing from that traditional sole proprietorship or law firm that provides those legal services. You can talk about really, and we're really kind of getting at ownership interests when we talk about alternative business structures. It might be some sort of law firm or other legal service entity that partners with a non-lawyer and gives a non-lawyer minority interest or ownership interest, or perhaps there is no restriction on any sort of non-lawyer ownership interest. It might be an ultimately like a business entity. You kind of hear some talks or maybe read some articles talking about is Amazon about to jump into the game, or Walmart providing legal services, a corporation that provides legal services, as opposed to a law firm that has a non-lawyer ownership interest. It's kind of a variety of different things, and I think we've seen different partnerships that have been proposed. Again, you can see in the materials, there's some of the descriptions, some of the articles that have been released, and I included actually under the ABS tab. There was an article that was released in March of this year talking about Arizona and Utah's experience with these types of entities, and they really run the gamut. We might be talking about an online only legal service provider. We may be talking about just simply a corporation and I think one of the ones that's highlighted in this article, or perhaps a different article, is talking about a company that created a subscription service that for $9 a month, I believe, you could call and ask as many legal questions as you wanted from the individuals that are employed there, and then you could sign up for additional legal services if you needed particular legal representation in a matter. So these things really, it's hard to describe specifically because they could be so many different things. But it really comes down to essentially non-traditional types of entities that provide legal services, often with a non-lawyership or a non-lawyer ownership interest, and that can be partnerships, with a technology company to streamline your services and things of that nature, versus just like essentially an investment interest. Publicly traded firms, as we talked about, you may remember the very first meeting, we had this overview of what was going on over in the UK, and that was one of their things. In Australia and the UK, they had publicly traded firms that were, I guess, authorized to exist back in the mid 2000s. And while there haven't been a ton of publicly traded firms in those different countries, there are some out there. And one of the things that we kind of learned from that process was that those processes, getting that additional capital, didn't necessarily impact their legal service, or excuse me, their fee structures in terms of reducing fees, but they may have been able to more, I guess, broaden their horizons to some extent as far as the legal services they provide. And it certainly, I think the conclusion was that it did not result in any type of harm. But the alternative business structure really can take so many different formats. And I think, again, I'll kind of look over at Jeff Kelly, knowing that, Jeff, you're going to be talking about regulatory sandbox. I think some of that alternative business structure kind of gets incorporated into the regulatory sandbox idea to the extent that there's any appetite for a pilot project. So that's my meandering explanation of alternative business structures.
Thanks, Brian. That's helpful. And I'm reminded of an email we got early on, just as chair of the committee, from a solo practitioner who wanted his wife to own a third of the law practice, and our current rules don't allow that. And he said, why can't my wife, she's managing everything, why can't she be, a minority owner? And our rules don't allow that. And so I think it's all the way from that to, to the mega, 1,000 lawyer firm publicly traded on the Australia Stock Exchange. So you got a wide range. And I think you summed it up nicely. I think part of the concern is not much evidence of any improvement in access to justice or meeting legal needs through the changes. On the other hand, not a lot of evidence of harm. I think the justification for the rule is lawyers need to make independent decisions representing their clients. And if you're, if you're following, earnings requirements from a CEO or from shareholders instead of professional judgment, there may be an impact, but not a lot of studies show that. And hard to frankly see that in the wife owning a third, how that's really going to change the lawyer's professional obligation. So we have interesting views on both sides. Who wants to chime in, ask questions, pro, con? Mac.
I don't remember whether I voted no or maybe on this one, but the bottom line for me is that I don't understand how this makes anything any better for access to justice. And if that's the problem we're trying to solve, or at least if that's the highest priority issue for us to attack, this feels like not on the list.
Alice?
So Mac, I can just tell you what the justification for it was.
Yeah.
Is that if you could bring in more financial resources into law firms, that they could invest more in technology and make themselves more efficient, and that would have the effect of reducing the cost of legal services, because they would be using technology to lever their existing resources and creating a lower price point for legal services. That was the theory. I don't know that it ever proved to be true in practice, but that was the theory behind it.
And my response to that would be a bank loan would do the same thing.
Yeah. I see Jeff Kelly, and then I see Jeff Summerlin Long. Go ahead, Jeff Kelly.
Yeah, I'll just echo kind of another part of Alice's point. Part of the argument that at least I've heard is, in addition to sort of outside funding, you also have a lot of other professions that could lend their expertise in a way that right now it's very difficult for law firms to attract top technical talent and things that would allow for innovation that frankly we're just blind to as far as solutions that could be devised and built. And that way of doing business will, in that respect, make the offering of legal services more efficient, or offered in a way that is not currently in existence. So I don't know that the rules have relaxed enough in other jurisdictions that we're seeing that. So to your point, is it making it worse or better? It may not be the conversation you want to have, but I will say that of the quote unquote high risks, and not to spoil the next meeting, of the high risk companies, there's only one in Utah. It's a legal services corporation or a legal services company that is offering software solutions without direct attorney input. So you can see where that justification and that argument might be taking a little bit of root. But I'm kind of struggle with the dynamic of, on one hand, personally, I'm less bothered by no harm and no improvement isn't as bad. But if the goal is affirmatively, we must be, access to justice focused to get approval, then, it's not going to be a compelling argument.
Thanks, Jeff Kelly. Jeff Summerlin Long.
I mean, another sort of theoretical justification would be for various social services organizations to be able to have an in-house attorney, sort of like insurance companies. And you see this a lot with environmental groups in particular. And it's an efficiency argument. So I worked with an environmental group out in the western part of the state, and they partner, right, with Southern Environmental Law Center, and that kind of thing. But anytime you're partnering with another organization, there can be different interests slightly. There's the whole transaction cost involved. And so, again, the literature doesn't show that this has actually happened when they've tried this. I don't know that we have enough data to say for sure, but I've talked to several people and they would love to be able to just have an attorney on staff. So yeah, that's it.
Thanks. Other comments? I don't see any others. Brian, do you have I think we're good for a poll. Let's go ahead and run our poll and give me your thoughts on whether, again, we want to recommend to the Issues Committee further study on this idea of changing the, alternative business structures, changing some of the requirements that, any entity practicing law has to be a law firm owned by lawyers, which is my shorthand summary of the current rule. Well, it started out as a dead heat, very exciting. It's going back and forth like a horse race.
It's like the Olympics.
It is like the Olympics. I hope you guys have been enjoying it. It's been more
yeah.
fun than I expected. So, all right, we do have, it looks like a couple people that may not have voted, but that's also fine. Voting is not required. We'll go ahead. I think we can end the poll there. It looks like a 6-2. So yes, we will include this in a recommendation. And again, I think to Jeff Kelly's point, we're going to be talking next month about regulatory change, and it may well be that if we end up recommending the idea of a regulatory sandbox, it may well be that the sandbox is an avenue to explore some of these other changes, right? That's what we're seeing elsewhere. Like Utah, where you set up a sandbox and then you say, fine, as long as you're in this structure, you don't have to follow the normal ownership rules. So, thanks, Brian. All right, that brings us to topic number 3, closely related, but I think narrower. Alternative business structures is pretty broad. Fee sharing with non-lawyers is more narrow. Brian, quick overview of what we're talking about here.
Right. So just as you said, Mark, this is very similar, but it is slightly different. The big difference is that we're not talking about an ownership interest. This is that notion, the request that we've heard from other jurisdictions where lawyers have asked if I can set up a situation where, I give a portion of the fee earned to my paralegal. Not necessarily, again, not in an ownership interest, a third of all profits or anything like that. But this particular case, this could apply to both freelance paralegals as well as other administrative staff that I've brought you in for this particular case, and the deal is essentially 25% fee as opposed to just a straight employment agreement. This would require a change to our rules. Of course, Rule 5.4 sticks out, which currently does have a prohibition on sharing fees with non-lawyers. So, and this is something that was eliminated in Arizona's jump into regulatory change. This particular rule, along with Rule 5.7 with regards to law-related services, those two rules were just straight eliminated. And kind of piggybacking on that comment, and we talked about this back in January, but I think it just serves as a reminder that even though Arizona eliminated those rules, what they did to kind of, balance things out was really expand and strengthen their conflicts rules, imputed conflicts, and the responsibilities of lawyers in terms of serving as managers and supervisors, both of non-lawyers and lawyers in their firms. So it wasn't just a straight cut and we'll just let everything go. They really, I think, thoughtfully took the approach of, recognizing if there's going to be some sort of issue where professional responsibility or legal ethics becomes a problem, a concern, that it's clear that the rules of professional conduct point to the lawyer as being the person who's on the hook for any sort of failure in providing those services. So that's fee sharing with non-lawyers.
Great definition, explanation, Brian. Thoughts on this in terms of questions about it? In favor, opposed?
I have a question.
Yes, Alicia.
My question is, if you allow the fee sharing, how do you prevent the non-lawyer from running afoul of the solicitation rules that exist for the attorneys? How do you protect the clients in that way?
And Brian can add, I think in part the answer would be if you're sharing it and you're supervising it, like a lawyer can't have someone else solicit. A lawyer violates the rules if you have someone else do a solicitation that you couldn't do. So if I have my paralegal do it and the lawyer knows about it, the lawyer could be sanctioned. Although you raise a good point about, if the lawyer doesn't know about it and the paralegal is simply out there soliciting and they're not subject to all the normal rules, that does seem potentially problematic. Do you remember how Utah tried to deal with that, Brian? Was that part of their other rule structure? I can't recall.
I think they, one of the things they did, if I'm remembering correctly, Utah, I believe, eliminated their prohibition on solicitation as a part of their advertising rules. They just did away with it. I see the fee sharing thing as really kind of more of the back end, that it's not so much the solicitation. The lawyer is still responsible. I would imagine under our structure that the lawyer would still be responsible for any sort of solicitation, including solicitation that occurs kind of under his or her watch. We have the general, of course, that like you articulated, Mark, a lawyer cannot do or can't ask another person to do that which the lawyer cannot do. And I think that comes into play as well as even under 5.3, the responsibilities regarding non-lawyer assistance, as far as when a lawyer learns about, if they learn about and fail to correct that improper conduct, then that raises an issue under 5.3. So I see the fee sharing thing, like I said, is more of kind of I guess maybe an arrangement that a lawyer could enter into with a non-lawyer, whether we're talking about kind of come in and help me with this particular project, or I'm going to, I guess I will pay you support staff or whoever it is with, X amount percentage of my fees that I obtain. It's not an ownership interest. You don't get to direct any part of the business, but you will share in this fee that I get for this particular case. And I think it also raises, we've got some kind of carve outs there in 5.4 as well, as far as, advertising costs. We allow lawyers to advertise through these different intermediary organizations now, and fees come in, and as long as it's not supposed to be a split of a fee, but it is kind of a recognition that there may be kind of I guess a portion that the client pays that's supposed to be for marketing services, and I guess this would essentially, if you eliminated 5.4, drastically altered it, you would be you would need to kind of consider those different aspects too of how lawyers' current interactions with these different intermediary organizations would be affected by that. Perhaps it just cleans it up by just saying this is no longer an issue, but that's I still think lawyers would still be responsible for any sort of solicitations or solicitation that run afoul of the rules in particular.
Jeff Summerlin Long.
I mean, maybe I just don't fully understand what fee sharing means. But how is it different from them? The lawyer takes a case, they hire an outside company to do data crunching or whatever. And it's just a contract. and they pay them. If they happen to win the case, which if they took the case, they should think that they're going to win. Then they can pay them with the firm's money that came from the fee, right? And I see a lot of potential for abuse. And, it kind of reminds me to a certain extent of sort of the rise of dark money in politics. What's going to stop outside organizations from pushing lawyers to do something, and the lawyer's like, you know what, I don't think it's a winning case, or something like that, or just I don't know. I fear that outside influx of influence and money, to a certain extent, and again, that could totally reflect my lack of understanding. I was a legal aid attorney. We didn't get fees. So,
Hey, Brian and Mark, I'm trying to understand, how does the fee sharing concept tie into improving the access to justice focus that we're talking about here? That seems just to be a general, for-profit, have nothing to do with access to justice concept that may be beyond our purview. So help me understand how that's relevant to what we're doing here.
Sure. So I think I do think that this one, of all the ideas, this one is a bit more in the category of, if we are looking at true regulatory change, this is a question of, why does this prohibition exist? I think maybe the thought is also, as far as attracting good talent and retaining talent to provide better services and improve services. But I think and when it comes to this particular topic, the thing that I've heard the most is kind of a question of, well, why does this prohibition exist to begin with? And is this something that's necessary for today's structure? So, but I see Jeff and Steve have raised their hands, so I've said something that's woefully wrong. So I'm going to stop now and say, Jeff, you were first.
No, not woefully wrong. Actually, completely in support. Most of the substantive arguments I've heard are more on the sort of, if we're doing the rules again, why does this exist? On the sort of A-to-J argument, whether or not you find it compelling, there are kind of mechanical aspects to fee sharing that, if you think of like the Ubers of the world, right, where you have a different splitting of fees as it comes in. Even if we're talking about fractions for like a referral fee through a system, that makes the platform that enables people to find attorneys at a reasonable price and quickly more feasible. So whether or not that exists and whether or not you can make the argument without sort of unlocking the regulation, that's the type of structure that I hear as probably the most credible argument for why some of the existing fee sharing rules are problematic and an impediment to business models that actually do, even if they are, for profit or somewhat for low profit, it's a sort of categorical bar to that type of business model and operation.
Thanks, Jeff.
I'll just piggyback onto that by saying artificial intelligence is in its infancy, and whether it's ownership of law firms or fee sharing with innovators, the practice is going to be something so far different that we can't even envision it 20, 30 years from now. We don't know what it's going to look like. That's how, because it's on Jeff can talk more about this obviously, it's on an exponential curve, the ability of machines to learn, and it's going to have profound effects in healthcare. And I was kind of wondering the other day about, what are doctors doing about licensing and their ethical duties to their patients in light of how medicine is going to change far more dramatically than the practice of law, because it's more science-based, I guess. But the practice of law is going to change pretty dramatically, and access to it, just like Moore's law, is going to become cheaper and cheaper and more and improve in terms of its intellectual capacity by machines, I think. But that's an access to just, it's going to become cheaper and more available.
Thanks, Steve. Any other comments on this one? If not, Brian, if we're ready for our poll, let's go ahead and talk about sharing fees with non-lawyers. And it's back and forth, ladies and gentlemen, back and forth. The no's, now the yeses. Now it's tied up, going into a dead heat. What's it going to be? It's like, yes, we got 4-3, 5-3, super close. This is the Olympic version of polling. I just love that. Love the live reporting. Let's see. You get to see the questions. I get to see the results. It's very exciting for me. Everyone else only sees the final polling, which I guess we can now release. 6-3, including this as a recommendation that the council should continue to take a look at.
The swimmer from Alaska wins, Mark? Is that what you
Yeah, that's right. All right. Yeah, live coverage. I may have to do a photo finish on some of these.
Right.
All right, Brian, our last one from our earlier list is this, I want to make sure it's alternative admission to the bar, which actually can mean some different things. You want to tee this up for us here? And again,
Yeah,
if you need a refresher too, you've got the description tab is a good place to go.
Right, and we don't have any, I guess, any significantly great examples, because I think there's a lot of conversation, a lot of stuff in the works, but it seems other jurisdictions haven't entirely got there as far as new proposals. As you all may know, there are different ways that people are admitted to the bar across the country. Particularly, you think of California; they actually have a pathway whereby you don't have to go to law school. You can practice. You can essentially get a kind of losing the word here, but get your experience with a particular lawyer for a couple of years, and then become eligible for the bar. So I think that's kind of the question here, as far as, is it something that the state bar should pursue, recommend for continued study and potential development, the notion of qualifying for the bar exam? This is just sitting for the bar exam. Or I guess this is one option: sit for the bar exam without obtaining a JD. You substitute law school with an extended apprenticeship of sorts. The other alternative that we've seen is the question of diploma privilege. And really, this came up, as we all saw last year, with the pandemic, with the shutdown and the concerns over sitting in a very large room with a lot of people taking a test for a total of 12 hours over 2 days. The question of whether a law license should be granted based upon successful completion of law school. And I recall earlier this year, I guess it was early June, the ABA conference on professional responsibility had a session on the bar exam. And there was somebody from the uniform bar exam, as well as I know at least one law school dean that was really advocating against the bar exam, saying that, at this point, the bar exam has not really proven itself to be a great gatekeeper for those that can provide legal services. So it's a question to everyone, and I do look at it as similar to the perhaps the and I don't want to say like I'm advocating for this, but I was trying to look at this from a different perspective, and looking at our limited license that we're recommending. Is there a different way, if everybody still continues to believe that legal education is a worthy thing and something that everybody should go through if they're going to provide legal services? Is it something that you look at in addition to the limited license, or perhaps eliminating that barrier of the bar exam, or allowing somebody to sit for the bar exam even if they don't go to law school, and provide those legal services? It's I think it's a pretty significant change. Again, we have not seen any jurisdictions actually. I'm not aware of any jurisdictions actually changing their rules at this time. There's a lot of chatter, and this very well may be the next step. I certainly think the uniform bar exam has been the most recent example of kind of a change, but it's still sticking within the original structure of the bar exam leading to licensure. So that's alternative admission to the bar.
Thanks, Brian. And to try to anticipate Todd's question, I don't know that we've seen any definitive assessment of how this could address, the access to justice legal needs. Although I guess the presumption is if there's more lawyers to meet that need. And so to the extent that this provides alternative ways to begin practicing, you may increase the overall size of that lawyer pool. But again, we did not hear from anybody that had looked at it directly. I see Jeff Summerlin Long. Is that he may just be pointing. Okay. Jeff Kelly, you've got your hand up.
Yeah, and I should probably say full disclosure, it's a closed matter, so appearance of conflict of interest. I represented a applicant in last year's bar exam for reasonable accommodations. I'm very well versed in sort of the where the power structures are in the state as far as the state bar and judiciary's kind of formal position is. So the question I would actually pose to the state bar with that loaded piece fully concluded and behind me is is it the state bar's position that it actually has the authority, other than sort of general recommendations on the admission to the practice of law, to really make recommendations? Because the response that I got from the council in declining to hear certain requests was that resides with the Occupational Licensing Board branch through the Board of Law Examiners, and that any change would require legislative change to the structure. So I have lots of opinions about the admission and alternate paths, but I did want to kind of put that piece up front in the conversation.
I think that's a good question. And maybe Alice or Brian, do you guys, one of you want to address that?
I'd be glad to. Yeah, I think, and actually, if you look at the statute on the Board of Law Examiners, it seems to me it's fairly clear that the Board of Law Examiners is the entity that's responsible for establishing the criteria for admission, including it references specifically a bar exam in the, I think even in the first sentence or something like that. It's a way it's written is a little bit like, is it potentially optional? But I think there's a good argument that it's not, that the statute would have to be changed. But we have always treated the Board of Law Examiners as the licensing body. We've specifically tried to get away from being identified as that for a lot of reasons that make sense for us. But it's also a structure that's worked really quite well. I will tell you this, that the Board of Law Examiners is examining its requirements and considering making some additional changes within the requirements of the statute. So it's not done yet with them. But yeah, Jeff, I think you're right that we have the statutory scheme is set up so that we are not a licensing board and we have limited authority. We have some rulemaking authority relative to the board, but it's fairly limited.
So I guess following up, I think part of Jeff's question is is this committee or then the state bar even the right avenue to study and or make a recommendation that would change what is right now in the scope of the Board of Law Examiners? In other words, would that be, I mean, I guess we could recommend a change to the statute or to the scope of, what they do, but I think that is a good kind of threshold question to think about.
To me, it strikes me as something akin to the court navigators program. It may not be something that we have direct control over, but it's something that if this subcommittee and ultimately the issues committee and council wants to recommend, they could issue a recommendation.
Gotcha. That makes sense. So it's a change, but probably not one directly in our bailiwick, but it would be something we could suggest look at if we wanted to. Thanks. Other thoughts, questions around the idea of alternate admission? If not, Brian, you want to put up our poll? I'm just holding the suspense this time.
Yeah. Well, see
Everyone
if anybody
done?
else wants to vote. Give you a couple
We'll
more
give it 5
seconds.
seconds if you want to put in a vote. Okay.
All right.
All right, we have our first tie. So, so I think I can just report we're tied. And there is, I will candidly say as chair, I think there's only so many things. Oh, Jeff's got his hand up, so I'll call on you in a second. I do think there's a limited, I have some concern about just the resources of the state bar in terms of how many different things we want to try to simultaneously study. So I don't mind saying my sense as chair is if we're really divided on whether it's worth further study, my suggestion is that we prioritize the ones where we're more unanimous, like the limited licensure, rather than try to potentially have multiple committees. That said, and maybe going to be Jeff's comments, the Sandbox might be an opportunity to explore some options around this as well. But go ahead, Jeff. Is that what you're going to say or something else?
Actually, it wasn't, but any opportunity I have to plug the Sandbox, I will. But in all seriousness, even if it ends on a tie, the one thing and why I was a little bit hesitant to offer that kind of qualified question / cancellation of what I think the discussion was. Can we still, even if we're not recommending that it's our understanding that it is the state bar's authority or purview, that we're still generally supportive of these types of initiatives or these types of conversations? We've just determined at a preliminary level that it's not sort of within this committee's power to recommend that, right? I don't know if that's going to exhaust resource or spread too thin, but what I don't want to have is sort of a tie vote that prevents other people who might take up that conversation from saying, well, if the state bar is against this, or if it couldn't even make it out of a committee, then why are we going to look at it? As opposed to, I dropped a technical issue that I'm personally very aware of because it was my last summer, that I didn't want us making a recommendation being swatted down for not having authority, but at the same time, what can we do to support that?
I think it's a good point, Jeff, and I welcome others' thoughts. I guess my view would be we are not rejecting any proposal to the extent we're saying that this is definitely something, that's dead on arrival or we shouldn't spend time on. Certainly not with a tied vote. I don't think it's a rejection. It's more a matter of which ones at this point in time, based on our review, do we think are the priorities that we want to recommend that the issues committee take up. So it's I use the term issue spotting, and it's kind of the issue. We're trying to find the ones where we think there's real promise. And I do go back to me, our charge was in particular focused on how to address the unmet legal needs and access to justice. So, and again, that's where I think we've spent most of our time focused on some of those priorities that seem to offer an avenue to address some of those unmet legal needs. And while we don't have anything to point to, like unlike Ontario's limited licensure, we don't have something here to point to say, oh, if you let people just skip the bar exam, that will necessarily help the access to justice problem. I'm not saying it won't, but we haven't seen anybody come forward and say this is a way to solve that particular problem. So, but it's definitely not a veto. In other words, if someone wants to come forward with an alternative licensure proposal within the state bar or outside, obviously they're free to. I don't view this as a vote to say it's a dead end. It's just not a priority that we're going to recommend right now. Josh, I see you've got your hand up, and then Jeff Summerlin Long. Go ahead, Josh.
Yes, sir. I think you may have captured most of what I was going to say, but I'm not a big fisherman, but my term related to all of this, and I've used on other occasions, we can only have so much chum in the water at a time. And I think we've already over chummed it. Maybe I just picked up on a different set of body language when I witnessed this brief out at the issues committee, but I think we should be laser focused on what are the most pertinent things related to access. Full stop. That's just my opinion. Thank you.
No, thanks. I appreciate you sharing that, Josh. And I agree I think that is the right avenue and the priority is what we're focusing on. Jeff Summerlin Long.
Yeah, I don't disagree in terms of the prioritization. I think there is an aspect of access to justice and legal needs when you combine it with the changes. Law school is really expensive. And I have a lot of students who would love to be a lawyer, but who simply can't afford law school, and especially the ones from poorer parts of the state who want to go back home and want to be a lawyer at home, where they're not going to be able to make very much money. And it's true, especially in the eastern and western parts of the state, but I get lots from the eastern parts of the state in particular. Right now, we're in a situation where law schools are desperate for students and they're handing out a lot more money, which just didn't happen when I went to law school, at least. But, that aside, there's nothing that prevents us in the conclusion of our report of having a next steps, other ideas where we say, look, this is something that is interesting. We simply did not have the time to put into it to the degree that we would be comfortable making specific recommendations. Right? We do this all the time in academic writing, where we have a next steps or further research, and so I think as long as we keep it in mind and put good language in the report, then I don't have any problem with focusing on the other ones that are more direct and, more importantly, probably quicker in terms of increasing access to justice.
Thanks, Jeff. No, that's helpful. And it's a good reminder. And as many of you know, because of the time constraints and the wanting to get things going, I did not do a written report on our, what we did around paraprofessionals. I do think this committee will prepare a written report. My goal is to have that wrapped up maybe October timeframe. After we do regulatory change next month in August, maybe we'll have a meeting to sum up and we can talk about what that written report should consist of. So I think that is an important step we haven't done yet. Mac, I see your hand.
I want to take the other side of the argument Jeff just made. I get that there are a lot of interesting things in this study that would make some sense to do in a perfect world. But we've been trying now for 2 sessions just to get one bill related to the dues through the legislature. If we walk in with 5 things, we stand, in my view, very little chance of getting any of those. If we walk in laser focused on something that has merit and that can be sold to the bar, I think we have a better chance of getting something. I realize that in the good old days, when there were a lot of lawyers in the General Assembly and the Democrats who were more amenable to the kinds of things that the state bar might want to ask for, you could get more. Those days are gone. There is a hostility toward attorneys and our profession in the General Assembly. And I think if we are anything other than laser focused, we're going to lose. So although I have an interest in a number of these things past the limited licensure, I'm going to be stumping that we pick the highest priority items and put our eggs in those baskets and move forward with the things that have the strongest moral argument behind them. Thank you.
So, I'll just offer my rebuttal. I wasn't saying we go in with 4 things, right? That's just dumb. I think what we do is, we prioritize, what's the most important one to us? What's number 2? What's number 3? What's number 4? Whatever. We probably shouldn't go above 3, but I think if you take that to legislators and you say, this is what we really want, you might find people who are like, I like number 2 a little bit better. And then we can start tweaking, because all of these things overlap, right? And so absolutely, we should have a number one priority of, we think this is the best option right now to accomplish these goals. But here are some other ideas. And, you know, I think giving them options, it makes them feel like they're not being pressured to do X, because nobody likes that, politicians in particular. And so that's why I think it's important to have the other ones in there, but be very, very clear that, you know, it is our recommendation to do this first. Does that make sense? No?
Yes, I just disagree.
Okay.
Good. Hey, I mean, we're allowed, we're lawyers. I love the rebuttal counterpoint. Might as well have some good discussion. I was feeling like we're getting a little too everyone agreeable on everything. We got to keep it lively. You know, keep that YouTube audience engaged, keep our ratings up. I think that we had a report out from communications. I think we've had over 100 people watch these committee meetings on YouTube, which is higher than any other committee. So we're keeping things juicy. And I think it's this kind of, you know, the pointed dialogue that's getting us there. So thanks.
Sadly, Mark, I have to.
What would you say, Brian?
I was going to say, sadly, I've been watching our analytics, and when we started talking about alternative business structures, we went from 6
We
viewers
lost
to
them.
1.
I should have put this first. Yeah, really. I didn't really think about the audience and structuring. No, it's been kidding aside, I think it's a good discussion to have, and I really appreciate people jumping in. Any other comments or two other fairly, what I think will be fairly short discussions? Oh, wait, Lakeisha, I see your hand up. Go ahead.
I just wanted to chime in and say, I wasn't in this subcommittee, obviously from the beginning. And I find that the polling where we're saying yes or no seems so black and white, when a lot of these things that we discussed has these specific alternatives that I'm thinking, well, that sounds good, but then this other one doesn't sound good. But then when you get the poll, it's kind of hard to say, okay, am I yes or I'm a no? So I don't know if I'm agreeing with Jeff or am I agreeing with Mac that we should be focusing on things where it is much more of agreement and there's a clear path to moving forward. With some of these others that we discussed today, seems like we don't have that. And both in the vote, and I can't really tell in the voting because, like I said, I'm unsure how to vote because I agree with some of it, but some things I go, maybe not that. But how do you answer that in a yes or no poll?
I do think that's a great point. And you're right. A lot of these you may be in favor of some aspects of, you know, limited non-lawyer ownership with the spouse, but not the public stock corporation. So, you know, how do you vote yes if you think some are a good idea and bad? I think that's a very fair point. And I think part of that is also just the nature of our mission as a study committee is we're just trying to identify areas for further study. And then like the limited licensure, they will develop a specific proposal that you would then vote up or down. In other words, you may think in general, limited license is great, but not if it does, you know, all forms of family law. And so then you have to hammer out, well, what does that look like? You get a proposal that you could then vote up or down. And so I think your point's well taken that it's challenging. I wasn't even sure whether we should do the voting, but I think it's a way to try to get a sense of where people are in terms of either what the priorities are or the areas that we want to hand off for more development so that you could then actually vote on any specific proposal for change, right? Which we're not doing here. We're not really voting on a specific proposal. It's more, do we want to recommend this as a priority for study? And I think it's helped me to get a sense of where people stand. And I think to your point too, Lakeisha, as a way to hopefully address some of that, my thinking is when we do a written proposal and we work on an actual report, we may be able to specify this is a particular, fee sharing that we think may make sense and others may not, or this is a type of alternative business structure that maybe the committee thinks is worth exploring, although the whole concept isn't. I think there's still room maybe to provide some more guidance when we do our written report on those. It is a challenge, and obviously we got a lot of areas, so I'm just trying to think of a way to get a sense of where we are and keep moving forward towards a conclusion. But I hear you that it's a pretty broad thing we're polling up or down. There were two things that came up at Issues Committee that I at least wanted to briefly bring to the attention of this group. One was the idea of using, when we were talking about limited licensure, one counselor said, well, why don't we just use more law students or more law clinics? I know we do some of those. I think maybe to start, and I don't know if Brian or Alice, if you just want to talk a little bit about our current practice rules. I don't know that it wasn't, and to my recollection, not any super specific proposal, just the idea of, isn't there more law schools can do to help us meet these unmet needs?
Mark, I'll address that because I
Please,
oversee
go
the
ahead.
law student certification program. The law schools and the state bar have been working over the past, I guess, about 3 years to really liberalize the rules that apply to law students in clinical programs, and have expanded it to externship programs as well. The law schools, I think, are putting as much resources as they can into clinical programs because the students want it and the alumni want it. Law firms want students that are experienced and more or less practice ready and all of that. I don't think that is a realistic way to expand access to justice beyond what the schools are currently doing. I think they're all now trying to maximize that already, and there isn't a lot of rule amendments to be done. One of the big changes that we made, first of all, was that we clearly brought in externship programs under the umbrella of the exception, and I think it's 84-7A. Brian will tell me if I'm wrong about that. But anyway, we brought externships under that. We also eliminated the requirement that the student had to have at least 3 semesters under her belt before she could be in a clinical program. Now, if the law school determines that the student has the experience and knowledge appropriate, even a first-year law student can be a part of a clinical program. So the subject matters, are broad now. Many law schools have all kinds of subject matters. The one limitation that's in the statute is that the statute specifically says that the students are providing legal services to those who cannot afford legal representation. You could expand the law school clinical programs by eliminating that language, but then you also are moving contrary to the whole concept that, well, law students can help meet the access to justice gap. So I personally don't think there's a lot more to be done there that would address access to justice issues.
Thanks, Alice. I just wanted to see if Mac, go ahead.
Alice, is there, my gut would be that the assistance those law school students provide is in the urban areas where the law schools are. Is that correct, or are they able to reach out into rural areas?
Yeah, they do a little reaching out into rural areas. They do some programs where they go on the road and, we'll, like over a spring break, they'll go somewhere and they'll do expungements. They'll do, wills clinics and those kinds of things. And very typically they are going into more rural areas, but just the typical clinical program that's associated with the law school during a normal semester, the clients of those clinics are typically local folks, and most of the law schools are in urban areas. So you're right about that.
Hey, Alice,
Also, Todd, and then Jeff. Go ahead, Todd.
Alice, aren't the law students also practicing under the supervision of an admitted attorney overseeing the clinics or not?
Oh, yes. Yeah, that's a requirement.
So that's a little different than perhaps what we're talking about with the paraprofessional.
Absolutely.
Yeah, okay. All right.
Jeff Kelly.
Yeah, so this will piggyback off of Alice's point about, yes, there is a lot of concentration around where the law schools are, but I am curious where, given that our entire courts have had to operate remotely for the past year, how much that sticks around. And there have been some very serious conversations, at least around the Chief Justice's different task force on COVID, the sort of innovation subcommittee. And I spoke to them a few times. We're really floating the idea of, can law school clinics, even if it's not sort of in the immediate traditional kind of pro bono services context, can they absorb certain types of matters in a way that free up court resources or legal services resources to do the pro bono directly, if there are things that they handle very efficiently in a way that, if there is a clinic that handles a particular area of civil discovery and they can suddenly reduce the court's burden on those types of matters. That was something that I don't know where those conversations go, but it's sort of an oblique way of using existing resources to tackle in a different way AHA problems.
Thanks, Jeff. Anybody else have thoughts, comments on this? Again, it's not something we necessarily need to act on, but since it was raised at the Issues Committee, I just wanted to bring it back and see if anybody had any further thoughts or input. The last item that was raised at the Issues Committee, one counselor suggested we recommend a change to Rule 16, the very last page. I think it's your last page of your materials. No, there's a little more on it, but it's at, let's see, it's for me, page 267 has the language of Rule 16, and it says, once you make an appearance, you can't withdraw unless the court allows it. Obviously, I think the courts want that rule because they don't want lawyers jumping in and out. I think the counselor that suggested this was concerned that if he wants to do a limited representation, show up for somebody to contest an initial hearing, he's not sure the court's going to let him out, and therefore his ability to limit representation is somewhat limited. So he was suggesting maybe the court, our committee consider changing Rule 16. I will tell you as a litigator, I have some concern that that's going to be met with a lot of opposition from judges that want the ability to say who is or is not before them. So I think, it's going to be very difficult to get some agreement that the judge has no power to not let somebody out. But I wanted to, again, raise this here and see if people had any thoughts. And again, what we have done in our ethics rules is made it clear that you can agree with the client to limited scope representation. You can say, I'm going to handle this hearing, but I'm not going to handle the whole case. That you can do ethically. And we see limited representation quite a bit. His argument was, well, if I'm a litigator, it's only so limited because once I appear, I need the court to let me out. But that was a question raised. I welcome thoughts or comments from folks. I know Todd and Mac, you guys are litigators too, and Steve. Yeah, go ahead, Steve.
I think we've hit up on the third restriction to your omnipotent jurisdiction today, Mark. I agree with you. Judges aren't going to allow this to happen. We've done, the bar, I think, has gone as far as it can in its ethical rules to allow for limited appearances. And as somebody who does a certain amount of unbundled practice, I can tell you that it works well for me. But there are those, cases that have jeopardy associated with being held in a case to them. And I just don't see how practically that's going to change without stepping on the judiciary's toes.
I totally agree with that. I don't need to belabor the point. I agree with it. We're not going to tie the judge's hands, in my view.
Okay. Any other thoughts? Sounds like we got agreement on that one. And again, I just not asking for action here. I just wanted to bring, since it was brought up at the issues, I wanted to see if people had thoughts on that. Any other, we're wrapping up, any other thoughts? So quick preview, again, next month, we're going to do the idea of the regulatory sandbox, and Jeff's going to talk about that, and I'm hoping we have some discussion. Again, there's obviously some overlap in all the other areas we've talked about, so it may be a good wrap up. We can talk about where regulatory sandbox may allow some of these other changes. And then my thought after that is maybe, and again, I may have to think about how we divide it up, but I think we start talking about what our written report looks like and how we get drafted, or have people help me draft that. I certainly can't draft it all myself, so I may make assignments. So think about what you may be willing to volunteer for. But then we'll be looking at beginning to put together a report that maybe we review in September and then vote on in October, perhaps trying to wrap up the work of this committee as we hand it back off to the Issues Committee and at least one, maybe more ad hoc committees going forward. So that's kind of where we are. Thanks everybody for your work. Any comments on where we are, where we're going?
Mark, I've got a question procedurally. I'm not sure exactly what the Issues Committee expects from us. Is it your understanding that the Issues Committee expects a full report that includes our recommendations and then lays out the rationale for those recommendations, or just recommendations that the Issues Committee will then decide whether to carry to the next level? I'm trying to understand. I've been listening to this, and I tend to agree that given the way the Issues Committee works and how procedure within the bar works, less is probably more in terms of what we suggest or recommend, quite frankly. I think that rifle shots are better than shotgun blast here, quite frankly. So, I mean, I'd like for us to think hard about what we will recommend and how we will justify the recommendations, whether we prioritize them or not, and really focus on what we believe we can move forward with. We can make all sorts of recommendations. I was certainly in the Issues Committee when you gave your report, and I was looking around the table as well. And we got to be careful how much we recommend, because the resources are limited, and setting up a ton of subcommittees or study committees may be met with some resistance. So I just think we need to think seriously about the structure and what we do, and whether we have our main recommendations, and as Jeff says, maybe have a separate section where these are the things we studied that might be worthy of further study, but they're not our recommendations. So I would like to get a better handle on what we as a group envision that report looking like as a final product, not now, but as we move forward.
I think your point's very well taken, and because I don't think we have, other than that we'll report out on our recommendations, we haven't been given a lot of specificity on what the Issues Committee is looking for. So I think we can decide what we want to do. And to me, it's a balance of, less is often more, and we want to focus on our priorities. The other part of me wants to capture some of the thinking and discussion and research we've done over the past year, something beyond making someone just go rewatch, all the meetings. So if we capture some of that, maybe it's in a different form of an appendix or some of the Jeff's idea of the follow-up. That's the competing things, I think. But I'm very sensitive. I agree. The bar's got a lot going on. And I think if we don't give narrow, focus, a lot can just get lost. So, and I don't want us to spend hours agonizing over wording on something that people just say thanks and never read either. So I do want to be thoughtful of how we do it. And let's put that on maybe even in August. We may not need the whole time on the Sandbox. Maybe think between now and then about the report, because Todd, you make a lot of good points about maybe it's shorter. I don't have a clear vision of what it will be other than some kind of report that we then vote on as collectively. Because I'm sensitive to Lakeisha's comment about, kind of just saying, yeah, it's worth exploring. No, it's not. It's pretty vague. And I think if we're going to do a final product, I'd love a report that, everybody, that we as a committee kind of adopt, that reflects some of the discussion and recommendations, more as kind of a culmination of our work. But it may be short, and it may be one option too is to prioritize, kind of like we did when we were doing the priority voting last time. So I'll think about that. It's a great point. Any other comments for today? I told you we'd finish early. It's 7 minutes before the 2-hour mark. So, it's early for us, but it's still a lot of work that we got done and a lot we went through. So I appreciate everybody's patience and great comments and discussion. So thanks. We will see you a month from now on Sandbox and begin to push towards trying to wrap up some of the work that we've been at. So thanks. Enjoy the summer while it lasts, and we'll see you again late August.
Thank you, Mark.
Thanks,
Thank you,
everybody.
everyone.
Thanks, everyone.